Since the pre-hearing at the Presidential Election Petition Tribunal, there has been speculation about how Tinubu's legal team will handle his various controversies, particularly his forfeiture of $460,000 to the U.S. government, which was traced to narcotic trafficking. The concern goes beyond whether he was convicted or imprisoned. It raises the moral burden of having someone with direct links to narcotics as the president of Nigeria. With Tinubu's legal team submitting their final address to the court, let's examine the reasons they put forward in defense of his narcotics-related past. The legal team argued that the petitioners failed to provide evidence of a fine mentioned in the documents, and one witness admitted the judgment was not registered in Nigeria based on Foreign Judgment Reciprocal Enforcement Act. This means it cannot be enforced in Nigeria. The team also emphasized that the witnesses could not prove any conviction as they did not present a certificate, sentence copy, fingerprints, or photographs of Tinubu, which does not fulfill Section 249 of the Evidence Act. The legal team cited the judicial precedent of Ogboru versus Ibori in 2006. The petitioners continued to plead for the withdrawal of the petition despite the hearing's ongoing hearing. However, it is notable that their arguments primarily rely on technicalities rather than denying Tinubu's links to narcotics. The absence of a conviction does not necessarily absolve someone of their actions. Many examples exist where individuals evade justice despite strong evidence against them. Therefore, the crucial question remains: would you trust someone with ties to narcotics to manage your company, let alone become the president of the country? The consequences for Nigeria going forward are significant. Does this mean individuals with worse baggage will contest and potentially become presidents in the future? A judicial precedent involving Muhammad Abacha and the federal government highlights that forfeiture is a result of a crime. If no crime was committed, forfeiture cannot be imposed. In Tinubu's case, how did substantial narcotics proceeds end up in his bank account if he had no involvement or intention to launder the money? The amount traced to his accounts far surpasses what he could have earned legitimately as an accountant. Abacha, too, did not go to prison, but forfeited billions of naira to the federal government. Will the honorable justices agree with Tinubu's lawyers that his lack of imprisonment absolves him of responsibility for the actions leading to forfeiture? Furthermore, citing the Ogboru versus Ibori case is not sufficient to dismiss the evidence of Tinubu's narcotics past, as Ibori's conviction in the UK did not go through the proper process in Nigeria, yet he was ultimately imprisoned. Tinubu's legal team did not address the issue of certificate forgery in their final court address, relying on the presented documents as evidence. The law permits someone to forge a certificate, even if they own it. The certificate Tinubu submitted to INEC may differ from the one issued by Chicago State University during his alleged graduation. Previous Supreme Court judgments have removed politicians in office for certificate forgery, and the outcome is eagerly anticipated. The legal team cited a Supreme Court ruling in favor of Shettima's double nomination, but new evidence from the Labour Party was not included in the trial. Tinubu announced Shettima as his running mate in a video, but Shettima later wrote a letter to the APC. The tribunal's decision is awaited. Concerning the 25% requirement in Abuja, the legal team argues that, according to Section 299 of the 1999 Constitution, Abuja should be treated as a state, implying that it should be considered as one of the 37 states, and all votes cast anywhere in Nigeria should have equal value. However, it is worth noting that Section 134(2) of the Constitution states that a candidate for the office of president must have not less than 1/4 of the votes cast in at least 2/3 of all states in the Federation and the Federal Capital Territory, Abuja. This requirement clearly indicates that after a presidential candidate scores 25% of the votes cast in a minimum of 24 states, they must also obtain 25% in Abuja. The intention behind this requirement is unambiguous, and attempts to argue otherwise are baseless. Even before the presidential election, many accepted this as the norm. But it seems the issue has been conveniently ignored because Tinubu did not achieve the required 25% in Abuja. Another hint supporting the mandatory 25% requirement in Abuja can be found in Section 134(3) of the Constitution, which addresses the situation when no clear winner emerges after the first runoff election. It does not require 25% in Abuja, further affirming that the requirement is intentional. Abuja is the federal capital territory, not a state, as it lacks a governor, a House of Assembly, and local government areas. Abuja is under the control of the president, who appoints a minister to oversee its affairs. The National Assembly also approves the budget for the Federal Capital Territory. Thus, despite the legal team citing Section 299, Abuja is distinct from a state. It serves as the Federal Capital Territory, similar to Washington, D.C. in the United States. The president cannot function under a governor due to potential clashes of power. This separation ensures that the president exercises control over the territory and functions as its governor. Consequently, the argument that the 25% requirement does not apply to Abuja is unfounded. It is vital to uphold the law, regardless of personal preferences. Beyond the issues with the election and Tinubu's controversies, the unavoidable matter is the 25% requirement in Abuja. Nigerians are not pleading for the right thing to be done. They are demanding justice. This requirement is clearly stated in our Constitution, and no amount of legal and technical maneuvering can overturn it. All former presidents, including MKO Abiola, fulfilled this important requirement before being declared winners. Tinubu's case will not be an exception.